Here, I'm going to talk to you today about some consequences, and when I say consequences, I mean bad consequences of getting a victim's protective order leveled against you. You definitely do not want one of those. So this is not legal advice, it's for educational purposes, but there's going to be a lot of good content in here and I think you'll like it. If you've been served with a protective order, petition for protective order, by the way, call me right away, 918-277-4800, 918-277-4800 at the Cale Law Office. Your initial consultation is free. Another thing I want you to do is I'm putting up another video about the procedures of a victim's protective order case, kind of like the stages. It'll teach you the stages that the case will go through. Some really interesting stuff in there, so I think you ought to take a look at that as well, and there's some notes on that as well. Before we get started, I'm going to tell you a little bit about some definitions. Some of this you might already know, but a petitioner, that's the person that's bringing the suit, the lawsuit, or in this case, a victim's protective order. That's the person that's making the allegations. And then the defendant, well, that's the person that is receiving the complaint or the petition and is having allegations leveled against him or her. So just a couple of those definitions. I'm going to use those interchangeably or throughout this video. So let's get to the meat of the subject about consequences. If you're a vegetarian, I guess we're going to get to the root of it, whatever. So let's just set the stage a little bit. Let's say that you've been served and you're going to a full hearing and you contest the matter. And by the way, do not ever consent to a VPO, a victim's protective order. Never, ever, ever consent to that. And I talk about that a little bit in the other video about the procedures. So you've had your hearing, and because you didn't hire me, Tulsa criminal defense attorney Stephen Cale, you don't give a favorable outcome. The judge rules against you. So what happens next? Well, according to the state statutes, the court has broad powers. In fact, I'm going to read a little bit from the statute. It says that the court may impose any terms and conditions in the protective order that the court reasonably believes will put a stop to the abuse, stalking, or harassment of the victim or the family or immediate family of the victim. So the first thing is the court has some broad general powers or conditions they can impose on you. So those are some broad things. What are those broad things? Well, we don't know because it's going to depend on the circumstances of the case. The statute also provides for some specific things that the court can do when it issues a victim's protective order. One of the things that the court can do is order you to go to domestic violence treatment or counseling. Now, maybe that doesn't sound that bad, but it can be because one thing is it's going to be court ordered. If you don't complete it, then you can be in contempt of court, and that's punishable by up to 6 months in the county jail and or a $500 fine. So you definitely do not want that. Additionally, this isn't just 1 or 2 counseling sessions or treatment sessions. It's a 52-week deal, and it has to be approved by the Attorney General. So there has to be a program approved by the Attorney General's office, and it's going to last 52 weeks. That's an entire year. You're going to have to be evaluated before and after entering the program, and you pay for this, not the court, not the state, but you have to pay for it. And along those same lines, the court could order you to pay for counseling and treatment to the petitioner, the person that made the allegations against you, and make you pay for that. So if you have a petitioner that says, he did this to me, and you get ruled against, and she says, well, or he, it can be both men or women, can be a petitioner, I need counseling for this, and they demonstrate that, then the court could order you to pay the other person's counseling, okay? Then, another thing is the court can make you pay for attorney's fees, costs in the matter. So you can pay for court costs, service of process costs, that's when the sheriff's deputy serves you with the petition, attorney's fees, and the statute says, and other fees associated with the case. What are those other fees? Well, we don't know. That's for the court to decide. And by the way, there is a way to make the other side pay for your attorney's fees in this case. It's another good reason why you need to get an attorney in VPO matters, Victims Protective Order matters. So be sure to call me, Tulsa Criminal Defense Attorney Stephen Cale, 918-277-4800 at the Cale office. So now, another interesting thing about the Victims Protective Order statutes that are found in the Protection from Domestic Abuse Act is that the court can actually order you to transfer your cell phone and utility accounts to the petitioner. There will be an order directed towards the, let's just say, the cell phone company to transfer your account and your name to the petitioner's name. Now, the petitioner is going to be responsible for paying the bill. And same thing with utilities, transfer utilities. That's just to ensure that the petitioner has some continuity and cell phone access and utilities. That's one thing that the court could order you to do, and you definitely don't want that. And if the petitioner is the custodian of children, maybe you have children in common, the cell phone numbers of the children can also be transferred by court order to the petitioner. So counseling, attorney's fees and costs associated with the action, transfer of your cell phone and utility accounts. And then also there's some criminal implications to getting a protective order. Federal law prohibits anyone who has a VPO, a Victim's Protective Order, from buying, possessing, transferring, receiving firearms or ammunition. So if you have any of those and you have a VPO, you are in violation of federal law. And check this here just a second, the penalty for that is a pretty hefty penalty, up to 10 years in prison and up to a fine of $250,000, so $250,000 that you could be fined if you violate that for possessing, transporting, shipping, receiving any firearm or ammunition while you are subject to a Victim's Protective Order. So another thing is that you can be punished in state court for violation of a protective order. That's punishable for up to a year in the county jail and or a fine of up to $1,000. For a subsequent violation, it's a fine of between $2,000 and $10,000. So you don't want to set yourself up for either a state or federal violation. All right. Now, how long can a protective order last? Well, the statute says up to 5 years. It doesn't have to be 5 years. It can be up to that, but it can actually be longer than 5 years. So if you are in jail at the time, or prison at the time that the VPO, the protective order, was entered against you, your time in jail or prison doesn't count towards the 5 years. So let's just say you were in jail for a month and during the time of the hearing, and the order is for 5 years. Well, it's not going to actually be 5 years. It's going to be 5 years plus a month. Whatever time you were in jail or prison, it's going to be extended to that. The court can also extend it by application of the petitioner. There's some factors. I'm just going to read those off to you. If you have a history of violating protective orders, if you have been previously convicted of a violent felony, if you've been previously convicted of stalking, or the court finds that you're just a violent person, those are some factors that the court can find to extend the Victim's Protective Order beyond 5 years. So as you can see, there's some pretty stiff consequences to having a Victim's Protective Order. Not only that, all these things I've talked about, if you are looking for a job and have a Victim's Protective Order against you, or you're trying to get some housing, there's going to be probably a background check, and if that VPO shows up, not going to be good. You may not, necessarily be denied a job, but it's, you could. Employers don't like that. If they see that you have a VPO, a Victim's Protective Order, issued against you, they're not going to like that at all. Same thing with, maybe some housing. If you're trying to rent a home, rent an apartment, they're not going to look favorably upon that. So, if you've been served with a petition for protective order, get an attorney. Don't go at it alone. You've got to fight these things. These things can be defended against. I've had some dismissed, reduced the impact. A lot of them get dismissed if somebody hires an attorney. So you definitely want to do that. Call me, Tulsa Criminal Defense Attorney Stephen Cale, 918-277-4800. Okay. I want you to take a look at that other video about the procedure concerning VPOs.